We're going to start in about 1 minute. Madam Secretary, are we ready? Madam Secretary, you don't have a role. This is committee of the whole. Never?
Hi, Mr. Chairman. Yes, we are ready.
Are you ready? I'm calling to order this meeting. This is a meeting of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Tuesday, January 23rd, 2024. The time is 12:45 in the afternoon. And this meeting is being held in the Council Chambers, Room 500 of the Johnny Wilson Building. Although I believe there are a couple of members who are participating virtually. And as always, this meeting is being broadcast on Council Channel 13 and is also available on the council's website, which is www.dccouncil.gov. We begin our committee of the whole meetings with determining whether we have a quorum. Mr. Cash, would you call the roll, please?
Chairman Mendelson,
Present.
Councilmember Allen. Here. Councilmember Bonds.
Here.
Councilmember Fruman.
Here.
Councilmember Gray.
Here.
Councilmember Henderson.
Here.
Councilmember Lewis George.
Here.
Councilmember McDuffie.
Here.
Councilmember Nadeau.
Here.
Councilmember Parker. Councilmember Parker, Councilmember Pinto. Councilmember Pinto, Councilmember Robert White.
Present.
Councilmember Trayon White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Mr. Cash. There is not a legislative meeting today, so we just have this meeting with several items to be marked up, as well as a number of items that are being processed through from other committees. First, we have the filing of committee reports. I'll recognize the Chair Pro Tem, Mr. McDuffie.
Thank you, Mr. Chairman, and I will move to waive the reading of the Secretary's report.
There's been a motion to waive the reading. Is there discussion? On the motion to waive the reading, all those in favor say aye.
Aye.
Are there any opposed? I don't see any no votes. The ayes have it unanimously. We have the reading of the Secretary's log of introductions and referrals. Recognize the Chair Pro Tem.
And I move to waive the reading of the Secretary's log of introductions and referrals.
There's been a motion to waive the reading of the Secretary's log. Councilmember Henderson, did you want to be recognized?
I did, Mr. Chairman. I wanted to ask a question about the log, if I could.
Yes, I understand you have, no, I don't understand. I know that you have a re-referral request to me. And I understand that that's what you want to ask about. And I will look at that and make a decision before the next meeting.
Great, thank you.
And I also have a re-referral request from Councilmember Bonds, and I will handle that as well.
Chairman, would it be possible to know what those re-referral requests are?
At the moment, I don't remember. Councilmember Henderson, what was the bill?
Mine was the Public Incentive Transparency and Accountability Act of 2024, Bill 25-659.
Councilmember Bonds?
I am not sure of the bill number. Wasn't expecting that inquiry today, but I'll be very happy to get that information to Councilmember Nadeau.
Okay.
Thank you. Mr. Chairman, I can jump in if you'd like.
Yes, please.
Geez.
This is exciting. We haven't spent this much time on a log in a while.
I thought I could jump in. It is Bill 25-621, the Safe Workplace Act.
Okay. Any other questions? or-
Yes, Chairman,
Yeah.
regarding the re-referral of B 25-659, I would like to join in support of Councilmember Henderson's request. Would you require a memo from me as well?
I require a memo. I would say no, it might help if you sent me a brief email.
No problem.
Thank you. If there's nothing further, the motion was to waive the reading of the log. All those in favor say aye. Aye.
Aye.
Are there any opposed? Don't see or hear any no votes. The ayes have it unanimously. We have three measures for markup in the committee of the whole. The first is PR 25-543 entitled District of Columbia Judicial Nomination Commission Marie Johns Reappointment Resolution of 2024. This resolution was introduced by me on November 30th. The purpose of the resolution is to reappoint Marie Johns as a non-lawyer member of the District of Columbia Judicial Nomination Commission for a 6-year term to end April 7th, 2029. The Judicial Nomination Commission is responsible for screening, selecting, and recommending to the President of the United States candidates for appointment to the Superior Court and the DC Court of Appeals. The commission recommends 3 candidates per vacancy. The president may nominate only those individuals who have been recommended by the commission. The commission is also tasked with designating the chief judges for both of these courts. The commission consists of 7 members, all of whom shall serve for terms of 6 years, except for the President of the United States' appointment, who serves a 5-year term. Members of the commission must be citizens of the United States, district residents, and shall not be an employee of the United States government, except that the chief judge of the U.S. District Court for the District of Columbia's appointment may be an active federal judge serving in the district. The council appoints 1 non-lawyer member to the commission. The mayor appoints 2 members to the commission, one of whom must be a non-lawyer. The Board of Governors of the District of Columbia Bar appoints 2 members, both of whom shall have practiced law in the district for at least 5 years before being appointed. The President of the United States appoints 1 lawyer member to the commission. And the committee report is a table. We try to have on all of our reports accompanying appointments and confirmations. So in addition to Marie Johns, this is a reappointment and she's currently serving as chair. There is Benjamin Wilson, who's a mayoral appointment, Linda Kropp, former council chair, who's a mayoral appointee, Judge Tanya Chutkin, who is appointed by the chief judge of the U.S. District Court. The 2 DC Bar appointees are Vincent Cohn Jr. and Yada Ford, and the President of the United States appointed Addie Schmidt. Marie Johns is a Ward 3 resident. She is the Chief Executive Officer of the legal and consulting firm PPC Leftwich, LLC. At PPC Leftwich, Ms. Johns focuses on the following practice areas: management consulting, small business advisory services, utility regulation, and local government affairs. She has over 30 years of public and private sector experience, as she previously served as the Deputy Administrator for the U.S. Small Business Administration under Barack Obama, and also served as President and CEO of Verizon Washington and Bell Atlantic Washington, D.C. In addition, she serves on the boards of Howard University, the D.C. Chamber of Commerce, the Federal City Council, Hager Sharp Inc., City First Bank of D.C., and the Girl Scouts of the National Capital Area. As I said before, I introduced this resolution on November 30th. The Committee of the Whole attempted to have a public roundtable on December 20th or 21st. We ended up adjourning that and holding a public roundtable on January 10th of this year. The committee received no testimony or comments in opposition. The hearing, the roundtable was actually quite lively with Councilmember Parker and me going at each, well, I went after him, and we both asked a lot of questions of the nominee. Without objection, I'll move both the print and report together with leave for staff to make technical conforming and editorial changes. Is there discussion?
Mr. Chairman,
Councilmember Parker.
Ms. Johns brings a very impressive background, and I'm looking forward to voting in favor of her renomination to the commission. You alluded to some of the discussion we were having at the hearing, and I wanted to reiterate for the record my strong feeling that the Judicial Nomination Commission should in fact entertain the ideology of judges that they are nominating. It was made, or we were made aware that a judge's ideology or their philosophy of law does not really come into account in terms of the Judicial Nomination Commission's process. And so at a time when there's a question whether or not the President of the United States can commit any crime with impunity or women's rights are under attack, I think a judge's philosophy is very important. And so again, I was heartened to hear Ms. Johns say that she would take that back to the commission and that they would in fact revisit it, rethink about it, and perhaps change their approach to a nomination process. But overall, I think Ms. Johns is a great candidate and she's done a lot of great work on the Judicial Nomination Commission. I look forward to voting for her. Thank you.
Thank you. Any further discussion? The vote will be on the print and report with leave for staff. I guess because there are a couple of members virtual, we'll do a roll call. Mr. Cash, would you call the roll?
Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The print and report with leave for staff are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed,
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for the February 6th legislative meeting. The next measure for markup is PR 25-581, Historic Preservation Review Board, Marnique Heath, Confirmation Resolution of 2024. The purpose of this resolution is to confirm the mayor's nomination of Marnique Heath for reappointment as an architect member of the Historic Preservation Review Board for a term to expire July 21st, 2026. Ms. Heath is a Ward 3 resident. She is a practicing architect with 25 years of experience, and she holds an architectural license in the District of Columbia. She's a principal in the Washington Office of Studios Architecture, an international architecture firm specializing in workplace, civic, institutional, and mixed-use projects. Ms. Heath has served on the Historic Preservation Review Board since 2016. She was originally nominated as a public member and then as an architect member. She currently serves as chair of the board. Prior to her service on the HPRB, Ms. Heath served on the district's Board of Zoning Adjustment and chaired that board during the last year of her appointment. She has served as chair of the Historic Preservation Review Board since 2017. The Historic Preservation Review Board was created by the Historic Landmark and Historic District Protection Act of 1978. This law includes a section declaring the purposes behind the legislation, which include to protect and enhance landmarks and districts which represent distinctive elements of the city's cultural, social, economic, political, and architectural history. To in turn safeguard the city's historic, aesthetic, and cultural heritage in order to foster civic pride in the history of the city, to enhance and perpetuate tourism, to bolster the economy, and to generally promote the use of the district's landmarks and historic districts for the education, pleasure, and welfare of the people of the city. The board is composed of 9 members appointed by the mayor after confirmation by the council. The district's law requires that the board shall be constituted and its members qualified in order to comply with the requirements for a state review board pursuant to the National Historic Preservation Act of 1966 and the accompanying federal regulations. And with that compliance comes some funding from the Department of Interior. During her confirmation hearing, Ms. Heath stated that she looked forward to continuing to work collaboratively with the Office of Planning, the Office of Historic Preservation, the DC Preservation League, the Historical Society of the District or of DC, local ANCs, and other district stakeholders to advance the preservation sustainability, and thoughtful development of our neighborhoods and communities. Ms. Heath meets the qualifications for serving on the board and has demonstrated knowledge of and interest in historic preservation. Thus, the committee, assuming this is approved, recommends council approval of PR 25-581, the confirmation of Ms. Heath for reappointment as an architect member of the Historic Preservation Review Board. This legislation was introduced on December 22nd, 2023, although we actually didn't see it until the first week of January. It was the Committee of the Whole held a roundtable on January 10th. The committee received no testimony in opposition to the nominee. I will note that the Preservation League not only testified in support of the nomination, but raised concern over the high number of vacancies on the board that threaten the loss of quorum and thereby potential noncompliance with federal regulations regarding historic preservation and associated funding. Without objection, I'll move both the print and report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? I guess we'll do a roll call vote. Mr. Cash?
Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen. Yes. Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson. Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The print and report are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for the February 6th legislative meeting. The third and final item for markup in the Committee of the Whole is Bill 25-317, entitled Extended Students' Right to Home or Hospital Instruction Amendment Act of 2023. The purpose of this bill is to add pre-birth complications, childbirth, and postpartum recovery to the list of health conditions which render students eligible for home or hospital instruction under the Students' Right to Home or Hospital Instruction Act of 2020. In March 2021, the Students' Right to Home or Hospital Instruction Act became DC law. The act requires every local education agency to adopt and implement a home or hospital instruction program beginning in the 2022-23 school year. The act also requires every local education agency to adopt and implement a home or hospital instruction program that provides academic instruction and support to students who have been or will be absent from their school of enrollment for 10 or more consecutive or cumulative school days due to a physical condition or a psychological condition. Each local education agency's home and hospital instruction program is designed to promote a participating student's academic progress by allowing the student to stay current with classroom instruction and core subjects to the greatest extent possible. The delivery of home or hospital instruction requires coordination between the classroom teacher and the home and hospital instructors to ensure that seamless reintegration into the classroom instruction can be achieved when the student returns to school. Students eligible for home and hospital instruction may be hospitalized due to a planned medical procedure, such as surgery that requires a long hospital stay, or they may have a chronic illness, such as sickle cell anemia, that causes them to have repeated intermittent absences that total more than 10 school days. Teen pregnancy and childbearing are associated with increased social and economic costs. Only about 50% of teen mothers receive a high school diploma by 22 years of age, whereas approximately 90% of women who do not give birth during adolescence graduate from high school. Bill 25-317 proposes an important clarification to the definition of health condition that will ensure pregnant and postpartum students are not denied home and hospital instruction because the regulations right now do not explicitly include pregnancy. The bill will allow students experiencing pre-birth complications, childbirth, and postpartum recovery-related health conditions to be eligible for home and hospital educational instruction. This bill was introduced by Councilmember Christina Henderson on June 5th, 2023, joined by, I believe, 4 other council members. And the Committee of the Whole held a public hearing on this measure on November 30th, 2023. And my recollection is that although there were quite a number of witnesses, there was no testimony in opposition to the bill. I move the print with leave for staff to make technical and conforming changes. Is there discussion?
Mr. Chairman.
Councilmember Henderson.
Thank you, Mr. Chairman. As you mentioned, currently when a student misses school due to a physical or mental illness, injury, or impairment, which prevents them from participating in the day-to-day activities typically expected in a traditional school day, they're eligible to receive home or hospital instruction by their LEA. However, due to an interpretation from the Office of the State Superintendent for Education, students who may be experiencing health conditions such as pre-birth complications, childbirth, or postpartum recovery are excluded from home and hospital instruction programs. We know that pregnancy, delivery, postpartum recovery, health-related conditions mostly affect teenage girls, or might mostly affect teenage girls and birthing persons in this student population, but also lower the chances of a student graduating from high school on time. Data from the CDC shows that 90% of women who do not give birth during adolescence graduate from high school, but that number drops to 50% for teen mothers. This legislation would dismantle some of the biases that we currently have regarding health condition, and overall just help students who find themselves in a situation where they might need this assistance. I look forward to getting this bill passed and ensuring that all students are whose health needs require common sense accommodations are able to get those met. Thank you, Mr. Chairman.
Thank you, Councilmember. Is there further discussion? We have the print before us. Mr. Cash, would you call the roll?
Councilmember Allen. Yes. Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The print is approved unanimously. I move the report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? Do a voice vote on the report. All those in favor say aye. Aye.
Aye.
Are there any no votes? I don't hear any no votes. The report is approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing are filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Does it have a fiscal impact?
There is no fiscal impact.
Without objection, this measure will be placed on the consent agenda for the February 6th legislative meeting. We will now move to consideration of measures from other committees. The first two were reported out of the Committee on Business and Economic Development, chaired by Councilmember Kenyon McDuffie. The first is Bill 25-56, Restaurant Revitalization and Dram Shop Clarification Amendment Act of 2024. Councilmember McDuffie.
Thank you, Chairman. Bill 25-56 would clarify and codify into statute the district's dram shop liquor liability laws. This is necessary because insurance premiums for liquor liability in the district are out of proportion with how infrequent such cases are actually brought. In fact, according to an insurance industry rating organization, the district's liquor liability framework is one of the top 3 jurisdictions with the highest risk to restaurants, bars, and other establishments that serve alcohol. Our neighboring jurisdictions, Maryland and Virginia, do not permit civil dram shop liability claims against establishments that serve alcohol. The high insurance premiums in the district have resulted in a situation where many establishments cannot afford to carry such insurance, which poses risk for both the uninsured establishments and for potential future claimants seeking to recover monetary damages. I appreciate my colleague, Councilmember Pinto, as well as Councilmember Henderson for introducing this bill. The committee made several changes to incorporate feedback from the Alcoholic Beverage Control Administration, licensed restaurant and nightlife establishments, Trial Lawyers Association, and other groups, as well as victim advocacy organizations. And I believe that the compromise we forged clarifies the scope of liability, preserves rights for individuals and families seriously harmed by violations, and will address the sky-high liquor liability insurance rates hampering our businesses. This takes a meaningful step to improve the district's business climate for our local and small, as well as large establishments. The committee also incorporated into this bill additional relief for restaurants, which Councilmember Allen, as well as I, have been working on for some time now. It streamlines managers' licensing and expands online workplace training. It tackles regulations of third-party meal delivery platforms and protects our restaurants from being excluded in search results within a 4-mile radius. And it also amends Title 28 to exclude service charges from sales for the purposes of calculating rent pursuant to a commercial tenancy and defines service charges for the purpose of this new section. These targeted reforms should make it easier for our restaurants to operate and compete within our region. Finally, this bill requires the executive to conduct a public education campaign regarding the District of Columbia Tip Credit Elimination Act of 2022. We've all heard complaints from customers, our constituents, workers, as well as restaurants about the confusing landscape as the tip credit slowly phases out. With that, I would move the resolution, ask that it be placed on the agenda for the February 6th legislative meeting.
Thank you, Councilmember. Are there questions from members? Councilmember, oh my, there's a lineup. Councilmember Lewis, George, and then Henderson, then Parker, then Truman, then Nadeau.
Thank you, Councilmember McDuffie and your committee for putting this legislation forward. My question is around, I guess, an issue is the language that excludes service charges as constituting sales when calculating rent, unless the lease says otherwise. Unlike tips, service charges are the property of restaurants, and some restaurants claim that service fees will go to workers. But this is hard to track and increases the risk of wage theft. Service charges add a layer of confusion to the complicated ways restaurants collect money and distribute it to workers. I know the Biden administration proposed a rule through the Federal Trade Commission recently to ban the deceptive use of service fees, which they described as junk fees. And so I just wanted to hear from you sort of how does this bill protect workers from wage theft if a restaurant promises workers part or all of the service fees? And if that's a concern, you're willing to work with me between first reading to try to find ways to help protect workers better.
Thank you for the question. I know there are a couple other members who this morning raised a similar question. And so hopefully my response tackles the questions that have been raised around this point. But I think it's important to start off by saying that service fees and under district law are not illegal. There are many different types of businesses that use service fees in their business model, not just restaurants, even though I think it's safe to say we as consumers generally don't like them. Some have asked that we outlaw these fees just as they pertain to restaurants, though, which I don't believe would necessarily be fair to single out the restaurant industry when it's just such a wide practice across our local economy, the region, and other parts of the United States. There are also some restaurants that actually pass on the service charges directly to their workers. And I also think there's a question about whether or not we would have the authority to just outright ban them. The federal government, as you mentioned, specifically the FTC, has been working on a proposed rule. And in my opinion, is probably the best, probably the most appropriate place for any broad changes to take place around service charges. My original hope with introducing the provision that was included in the introduced version was to clarify how restaurants needed to disclose the fees, because it was pretty confusing to a lot of people in order to prevent a lot of the customer shock that perhaps you all got inquiries about, as I did in my office. But this was born out of a consumer alert that the Office of the Attorney General issued last year that left restaurant operators confused about how to comply. You all might remember that. A little bit more time for my response, Mr. Chairman.
If there's no objection.
So at that point, I spoke with the Attorney General about this issue and asked that they issue clarifying guidance. I included that provision in the original bill because it was unclear whether the Attorney General had intended to issue additional guidance. However, after our hearing, in which they actually testified, the office did issue updated guidance spelling out how restaurants needed to disclose the fee and the fee's purpose in order to comply with the law. I thought that guidance that the OAG provided would put it into the need for any statutory changes. Since then, as you all are probably aware, several lawsuits have been filed against restaurants by private parties that take a more expansive view of the law than even the Attorney General's guidance. So there may be a need for us to revisit this, and I'm happy to work with you, Councilmember Louis George, or any of my other colleagues who have an interest in addressing this provision further.
Thank you.
Thank you, Councilmember Henderson.
Thank you, Mr. Chairman. Councilmember McDuffie, you partly answered my question. I did want to ask, how confident are you that the OAG Enforcement Authority is sufficient to enforce compliance with the new law regarding service charges and the consumer notice requirements?
That's probably a question more appropriate for the OAG. My estimation is that I'm confident that they have the resources that they would need and the ability to enforce. My interactions both with the OAG and the restaurant industry and my team's interactions with both indicate that there's been a level of communication. I think there was some initial shock when the initial guidance was released, but there have been subsequent interactions, meetings with both the industry and the Office of the Attorney General that I think have resolved to an extent the concerns that have been raised. It has not addressed all the issues that some have, including the need to file litigation, which if we think there's some more room for clarification, I'm happy to chat about it. I'm not sure where the litigation is going to go, though.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Councilmember Henderson. Councilmember Parker.
I want to thank Councilmember McDuffie and the rest of the committee for their work on this bill. I have two quick questions. One is around tracking data on how restaurants are using service fees. It's my understanding that there isn't currently a tracking mechanism. My conversations with the Restaurant Association seem to suggest they aren't looking at it. And what I just know from my own personal experience, some are passing the money on directly to workers. Some don't have service fees at all. Others have them at different amounts. And so one question is, if that's something that the committee is willing to look at in the future. And then secondly, I appreciate that the committee ultimately removed the cap for the dram shop component of the bill. And I know Alabama recently passed legislation without a cap that drove down rates, and to what extent the committee is tracking what's working in Alabama in hopes that it will do the same here.
I don't know how often Alabama's a state that we're looking to duplicate things here in the District of Columbia. I will say, though, it's a great state, by the way. I have really great friends from Alabama. One of whom I just communicated with yesterday. So no shade to Alabama, but yeah, we're tracking it, and it's one of the few places that has recently done this. And so my team and I have been communicating about what Alabama has done in terms of the caps, and we did look to it as an example of whether or not we needed to have caps in place in our bill. What was the other part of your question, Councilman?
The data tracking for service fees. Because right now it doesn't, and maybe I'm wrong, but it doesn't appear that anyone's actually collecting how restaurants are using the fees.
I don't know that anybody's collecting how any industry that has service fees are actually using the fees. And I'm not sure what that would even look like, because it is something that is used in industries in our local economy. I think it's gotten a lot of attention with restaurants because of the recent implementation and rollout of Initiative 82, and sort of the sticker shock, I think, of some consumers of seeing these fees, and whether the fine print or the notice that consumers have lends itself to clarity and proper notice about what they're paying for. So we have not included that in this bill. I'm not sure what that framework would look like. I'm also not sure whether it would be appropriate to do it for one industry and not for every industry that actually uses those fees.
Thank you. Thank you, Councilmember. Councilmember Fruman?
Thank you very much. And thank you, Councilmember McDuffie, or Chair McDuffie, for landing the plane on the dram shop law. I think getting to a place where the Restaurant Association and the trial lawyers were together shoulder to shoulder, a real accomplishment. I was told that, this looks like the Alabama law, and the Alabama law lowered scores from a 10 to a 5, which hopefully this will give the kind of relief to our restaurants that they're seeking. The restaurant industry is facing enormous challenges. We saw it in the newspaper today. I wonder, and I apologize for bringing this up in this setting, and hope we can work on this together going forward. It might sound odd to be skeptical of a public information campaign, but I am a little skeptical of the public information campaign. The way it's written, the mayor will put together a public information campaign about the changes made necessary by Initiative 82. Well, there is a lot in there. So right now, wages as a result of Initiative 82 have gone up by a small amount, but we have service charges of 20 and 22% that cover way more than the increased costs from Initiative 82 at this point, and likely even at the end of the day. So and there is very high passions around this issue. How do we guard against a public information campaign turning into a political campaign to try to throw off Initiative 82? How do we make sure that it accurately reflects the actual math? What was caused, or what is responsive to Initiative 82, and what is a broader change of policy, and maybe a good policy by the restaurants, but not necessarily flowing from Initiative 82? How do we make sure that this is a bona fide public education campaign and not part of a political agenda?
I appreciate the question, and I think it's an important question, but I also think it's important sort of the context that you mentioned before you asked your question. And I want to, if I could, Chairman, I know I'm around out of time, just ask for my colleagues' indulgence. I want to start with a really quick sort of fact check on why we're moving this bill, and frankly, why I think we need to do even more to ensure the health of our restaurant industry. If you listen to the CFO's revenue estimates that were published recently, the last several estimates have mentioned the strength of our hospitality industry, employment, and the revenues associated with the industry, and keeping our district government revenue stable, even when other revenue streams are declining. And I've heard this for the last sort of few estimates. And revenue means that we can pay for all the vital, programs and services that I think we all care about and that district residents sorely need and deserve. But I want to be clear that the hospitality is a broad sort of category, and it's really inclusive of a number of things. When we look at restaurants specifically, this is important. What we see in the latest round of data from the U.S. the U.S. Bureau of Labor Statistics should be alarming to all of us. It's alarming to me. What it shows is that staffing levels in the District of Columbia's full-service restaurant segment trended sharply lower since implementation of Initiative 82 in May 2023. Between May and November 2023, full-service restaurants in DC cut 1,300 jobs, which is a decline of approximately 4.4%. During the same 6 months period in 2022, DC's full-service segment added 2,000 jobs. All right, so a couple of years ago, added jobs, now we're cutting jobs. This is in sharp contrast to our neighbors in the suburbs. All right, so when we talk about regional competitive policymaking locally, what the impact is in the suburbs and in the region is important. In the region and in the suburbs, full service employment is rising. Between May and November 2023, full service restaurants in the DC suburbs added 2,000 jobs, which is an increase in 3%. I want to make sure we're not ignoring that and that we're taking steps to address that. I'm going to get to the other part of your question about the public education campaign, but I think there are a couple of important points to keep in mind. We're changing the paradigm when it comes to how restaurant employees are paid. Workers who were formerly primarily paid through tips are now going to be paid making the minimum wage primarily. Not to say that tips can't be provided, but in some cases, people are deciding not to pay them. They're encountering these service fees, and it's creating, I think, a bit of a stir and confusion. I think the public education campaign is necessary so that the public has a better understanding of the impact of the policy. How do we guard against politics? I think we have to do it in the same way we typically do it as legislators, which is an oversight of the executive branch agencies to make sure that what they're doing is in line with what we intend when we create these sorts of laws. And so I'm not going to suggest that it's not a possibility. What I'm suggesting and stating hopefully clearly is that it's important to explain to the public all that is going on, because so much is going on in order to implement Initiative 82. And a lot of what we're seeing appears to be having a negative impact on our restaurant industry in the District of Columbia.
Councilmember Nadeau.
Thank you, Chairman. Councilmember McDuffie, thank you very much for moving forward and congrats on the work that you did to bring compromise around a tricky issue. I'm glad to see that the committee print requires a study on food delivery worker conditions, which I know has been a subject of interest for many of us. I see it also includes some data reporting for food delivery, like vehicle used, assignment of trips, and cancellation of trips. I have been working with the Department of For Hire Vehicles on food delivery since they have new authority to enforce moving violations for food and parcel delivery drivers. And many pieces of the study of this bill overlap with what Department of For Hire Vehicles is already doing. So I want to make sure they're not written out of the bill completely. Can I ask that we work together between now and first reading to see if there are any modifications we can make to that part of the bill?
Certainly, I appreciate that.
Great. Thank you so much. Thank you, Chairman.
Thank you, Councilmember. Councilmember Allen.
Thank you, Mr. Chair. Rare is the day that we ever say we're tracking what's happening in Alabama. But we did it. So we'll write down the day and time. I appreciate Mr. McDuffie, the work that has gone into this. Before I get to my question, I'll share something I shared at our committee markup as well, that this bill really is a product of a lot of compromise and consensus. And so especially to the numerous stakeholders that were a part of these conversations, just appreciate everybody had to come to the table not get everything necessarily that they were looking for. But I think we landed in a very good place. It's going to make a meaningful difference. And I know that we prioritize making sure we actually get the job done. So I just want to make sure that folks know and hear the appreciation of multiple parties coming together to get that done. And thank you for helping lead through that process. I wanted to just speak briefly on one of the elements that was talked about a moment ago, because last spring I sat down with a number of our locally owned restaurants and businesses in Ward 6, and I wanted to know what are the things we could do to help? What can government do to help? That's to keep their doors open, to keep those jobs in place. And they gave a list, and many of those items are represented in this bill. And I thank you for adding them into this bill. I think it's that collaboration that's going to have this bill be a very meaningful difference. We had 50 restaurants close last year. We got restaurants that are facing more than a 20% increase just in the cost of doing business. That's separate from the rise in wages that they're having to pay. So that is going to have an impact. And we know that these locally owned businesses, we're not a city filled with cheesecake factories. We're a city with locally owned businesses, and that makes a big difference to have those spaces. But one of the elements here that I'd heard some questions about is related to allowing us to treat service charges the same way we're treating tips when we talk about the calculation for rent. And for folks that may not know, the way that a lot of these relationships work with a landlord and a restaurant is that their rent is calculated part of the sales that they have. And so if tips aren't included as part of that calculation for sales, if service charges, those trying to create some parity there. And the idea behind this was that making sure that the service charges are actually going to the employees. Wage theft is illegal. We have funded wage theft attorneys at the Attorney General's office to go after wage theft. If that's happening, it's illegal, and we have an Attorney General who would want to go after that. But I think you narrowly crafted this. We worked this so that it's very specific. And so just to make sure I wrap it up with a question, since it's the committee of the whole, Mr. Chairman, this is a lease agreement between a commercial landlord and the restaurant. So is it correct? We are treating our service charges, if they go directly to the workers, the same as tips in only that specific context. This does not have to do with overall workers' wages. This is about in that specific context.
Yes, the short answer is yes. And I appreciate the question because I think it helps to clarify what some perhaps thought about the.
I agree. And with my 2 seconds left, thank you very much. Thank you, Mr. Chair.
Thank you.
Thank you, Councilmember Allen. Any further discussion? Hold on a second. Second round, not discussion, questions. Councilmember Parker.
Despite Councilmember Allen's comment about the Cheesecake Factory, I did want to bring up a question about his last point, but to make sure I'm tracking. So are you suggesting, and this is Councilmember McDuffie, the bill that would allow restaurant service fees not to be counted towards the rent, is that only for service fees that go directly towards employees' pay? And so if a restaurant were to, let's say, collect the service fees into the overall budget or bottom line, that provision would not count. Am I understanding that right?
You are.
Okay. That was not clear, but that's even better. That's great news.
Yeah, no, I'd be happy for a council member because he has it up. I have to find it. But if you read the section of the law, yeah, if you could.
I would be delighted to. It's on page 5 of the committee print, and it's line 109 through 112. So purposes of this section, the term service charge means any mandatory fee paid as a percentage of the total cost of food or beverages if the food or beverages are served, and the fee is used to pay base wages or tips of the employee. So it's
Okay,
very
but that
specific.
then goes back to my earlier question around tracking. So how do we know, and I'm assuming restaurant owners are operating in good faith, but how do we know if the restaurant owner is passing on the service fee to employees or collecting it towards his bottom line? And right now, it's my understanding we have no mechanism to track that.
So there are already laws that require restaurant operators to report wages through DOES. And I think what's important to also acknowledge that if they're not doing this stuff properly, they would be committing fraud. And my experience with not only this bill, but with this council and our efforts around wage theft, I think have sent a strong signal about how seriously we take it. And there've been open lines of communication between my office and the Office of the Attorney General. And I would expect that if there need to be enhancements or other tools around this law or something associated with service fees, then I'm happy to have that conversation with any of my colleagues, but anybody else, including the OAG, who might have suggestions. I would also say, though, that I think it's important to make sure that we are acknowledging what's happening on the federal level with the STC and how many industries actually use service fees, because it is not uncommon to see service fees used and consumers pay them in other industries as well. And so I wanted to just point that out. So I think your point I think your question is important. But I think when you think about all the shipping and handling fees that we pay as consumers, they have a similar use in terms of how businesses are run, and that we should try to approach this broadly, which is why I said earlier that I think the federal side is probably the best way to try to deal with this.
Councilmember Bonds.
Thank you, Chairman. I just wanted to say to Mr. McDuffie, I guess in the form of a question, want to make sure that I am hearing that you want to have further discussion regarding service fees, because we're hearing from the community, and we're also hearing from loud and clear from the restaurant community that is in a spiral for recovery.
Yes.
All right.
absolutely.
I just want to make
No, I
sure.
appreciate that. Yes.
Thank you. Thank you so much.
Yes.
That is so important. And I think we all want to make sure that we have the opportunity to help this very important industry recover. And at the same time, we want to hear from the public and know that the public understands what a service charge is and how it can be used. And I do believe we need further discussion about that. Thank you.
Councilmember Pinto.
I was just gonna offer a thought about Councilor Parker's question. It's my understanding that due in large part to OAG's issuance of what would be compliant, now a lot of restaurants will have listed on the bottom of their menu what the service charge is going to be used for. So if it says this is really used to tip our employees, that is another indicator that that is an expense that can be deducted from your rent cost, just like many other expenses. Whereas if it's is stated, this is really absorbed in the cost of our operations, that is not an expense for purposes of deduction for your rent cost. So I would say that's one other marker of in practice of how we know these things are working.
Thank you, Councilmember Pinto. Councilmember Fruman.
So thank you. I think this all goes to just how complicated it is, because if it's for base wages and tips, that it isn't included in the total income that drives the rent calculation. But base wages and tips are very different. So it might be that what happens is you look at the total collected in service charges and you look at the total labor cost, including tips. And if the service charges are lower than that total cost, then they qualify for not being included in income. But the base wages actually are general operating costs. And so they ordinarily, and they would be treated as operating costs and income for the purposes of the sales tax calculation. Here, trying to do it on the rent side, I hear you. But if we get into a level of complexity, was there any contemplation given to only excluding those portion of service charges that were used for compensation over base wages as not being included in the calculation for rent? And in that setting, frankly, they shouldn't be included in the calculation for sales tax. But base wages and tips are totally conceptually different here. but they're combined in this section.
So two things, and I always appreciate, but in this case particularly, nuance in what we do. I don't know that the public always appreciates it. But landlords and restaurant owner operators, they can negotiate these things, but what we're trying to really target, a lot of these leases have already been signed before Initiative 82 to went into place, right? And the base wage that we were talking about pre-Initiative 82 is not the same base wage today. And I think it's important to draw that distinction when we talk about what's excluded, what's not excluded, and frankly, sort of what we were trying to get at when we were crafting this legislation, right? It's not requiring them to enter into these agreements. In fact, when these restaurants and these landlords enter into these agreements, we're trying to account for some of the situations where there is no, it doesn't really address this. It's not, so this would fill a gap if something's not already in the lease that spells out what's included in the calculation of rents. If that makes sense.
It makes sense, but what I was getting at before and still am getting at is a restaurant imposes a 20% service charge. And the increased costs related to I-82 today isn't 20%. And frankly, even at full implementation, it's not going to be 20% of their costs. And so I think we need to deal with that reality and figure out how to treat that portion that is attributable to increases in the base wage one way, and then the portion that is just about general base wages a different way, and if it's tips a different way still, if it's payment over the level of the base or the eventual base wage. I think it's just a really complicated terrain. And it's another reason why it really makes me worry about a public information campaign that might simplify it and make it seem like I want to help our restaurants. I'm with you, but all the ills flow from I-82. That is not right. And certainly not at this point. There's some increase in wages, but there's lots of other factors that are affecting it. And if we try to attribute it all to I-82, I think that's not accurate.
Let me be clear. I'm not attributing it all to I-82. In case there is anybody who that's not what I'm attributing to. I mean, I think if you read what's being reported, if you look at the data, there are a number of things that are impacting the industry post-pandemic. Although you saw strides being made post-pandemic around restaurant recovery, but then you had issues still related to inflation, et cetera. Labor cost is one of those things though. And if you look at our restaurant industry and performance since the implementation of I-82, it does raise questions about the competitiveness of our industry in our region, where we're the only industry that has implemented I-82. So I think you raise a very important point about increases by restaurant owners, 20% service fees, et cetera, what they are attributable to, whether it's base wages, whether it's, going to workers as a form of a tip. And I'm happy to grapple with all that stuff with everybody because it is complicated. And there are some complications though that fall from implementation of I-82 that I think the public would benefit from hearing about. I think we just have to make sure we're focused like a laser on making sure that's what DMPED does.
Thank you. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Does
There
it?
is a small one-time cost of $600,000. So not that small, but one time.
Thank you.
600,000.
Without objection, this measure will be placed on the consent agenda for the February 6th legislative meeting.
Is it on the consent agenda?
So I just said unless there's an
Oh,
objection,
I would object.
I'm sorry, you're asking it be on non-consent?
Correct.
All right.
Thank
This measure will be on the non-consent agenda for February 6th. There's a theory of meetings that if there isn't a lot of business, that the deliberative body will fill the space. So we have another, I think, 8 measures. We'll see. PR 25-506, Deputy Mayor for Planning and Economic Development, Nina Albert, Confirmation Resolution 2024. Councilmember McDuffie.
Thank you, Chairman. PR 25-506 would confirm the appointment of Nina Albert as Deputy Mayor for Planning and Economic Development to serve at the pleasure of the mayor. Ms. Albert is a native Washingtonian and Ward 5 resident and a well-qualified public servant who's led significant development teams in both the public and private sectors. She has a history of development in the district and with key private and regional partners. She also brings valuable experience working for the federal government, where she most recently served as Commissioner of the Public Building Service within the General Services Administration. I've known Ms. Albert for a number of years and support her nomination to lead DMPED during this critical time in the District of Columbia's history. As you all know, there are some really pressing challenges impacting our local economy, like the need for downtown and commercial office redevelopment, some of the challenges around less competitive post-pandemic business environment, retaining existing businesses in our city, attracting new businesses, both large employers and small businesses, attracting businesses like grocery stores and neighborhood serving retail in communities across our city, especially in places like Ward 7 and 8. And headwinds for building adequate affordable housing, which I know is a priority for this council. And for most of last year, DMPED was without a permanent leader. So I look forward to working with the deputy mayor to ensure that the district's best and most equitable days are ahead of us. With that, I would move the resolution as to be placed on the consent agenda for February's legislative meeting.
Thank you, Councilmember McDuffie. Are there questions from members?
Hold on, I had a question.
Madam General Counsel, is the measure legally?
She has a question.
Councilmember Lewis George?
Yes, thank you. And I've talked to Councilmember McDuffie about this, but I just wanted to get on record. Were you able to speak with Ms. Albert about the procurement of the Kennedy Street Library as a part of DMPED's actions moving forward?
No, I know. I reached out to her when you reached out to me today. I have not yet heard back from her. My team has also reached out to DMPED, and up to this point, we have not gotten a response. So I'm happy to coordinate with you and maybe try to get you a conversation directly with Ms. Albert.
Thank you. I appreciate it. Thank you.
Thank you. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for the February 6th legislative meeting. There's no objection. The next 2 items will be considered in block. They both concern appointments to the Board of Long-Term Care Administration. I should say the next 6 measures were reported out of the Committee on Health, chaired by Councilmember Christina Henderson. PR 25-560, Board of Long-Term Care Administration, Dr. B. Michelle Harris, Confirmation Resolution of 2024, and PR 25-561, Board of Long-Term Care Administration, Judy Brinkerhoff, Confirmation Resolution of 2024. Councilmember Henderson.
Thank you, Mr. Chairman. So for the Board of Long-Term Care Administration regulates the practice of nursing home administration, assisted living administration, and the home health care administration here in the District of Columbia. PR 25-560 nominates Dr. B. Michelle Harris for reappointment to the board for an allied health professional license in the district who has demonstrated interest in long-term care. Dr. Harris is currently the interim chair of the board. She is a licensed dietitian and an associate professor at the University of the District of Columbia, where she teaches nutrition, including geriatric nutrition. She is also a health correspondent for the East of the River newspaper. Dr. Harris received her PhD from the University of Maryland, and she is a Ward 4 resident. PR 25-561 nominates Judy Brickenhoff for appointment to the board as a health professional with experience in long-term care. Ms. Brickenhoff is a registered nurse in the district and has served as a school nurse in the district for more than 20 years. Prior to that, she had a long career in the military. She received her Master's of Science in Nursing from the University of Texas, San Antonio, and she is a Ward 3 resident. The committee held a hearing on these nominations on January 10th. At the confirmation roundtable, we discussed with the nominees the proposal in the Health Occupations Revision Act to sunset this board and move the work under the Board of Nursing. There was general support, but they did advise ensuring that the allied health professionals and long-term care not get overlooked. I was happy to hear that both of these excellent nominees would be willing to serve on the board so long as it is currently functioning. The committee unanimously approved these nominations on January 16th, and I now ask that these nominees be placed on the consent agenda for the legislative meeting in February.
Thank you, Councilmember Henderson. Are there questions from members? Madam General Counsel, are the two measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Yes.
Madam Budget Director, do the measures physical impact statements comply with council requirements?
Yes.
The objection, these measures will be placed on the consent agenda for the February 6th legislative meeting. The next three measures, if there's no objection, will be presented in block. They concern appointments to the Board of Professional Counseling. PR 25-574, Board of Professional Counseling, Rhonda Brown, Confirmation Resolution 2024. PR 25-575, Board of Professional Counseling, Victoria Shirk, Confirmation Resolution of 2024. And PR 25-576, Board of Professional Counseling, Giovanna DeLoro, Confirmation Resolution of 2024. Councilmember Henderson.
Thank you, Mr. Chairman. The Board of Professional Counseling oversees counseling professionals in the district, including art therapists and addiction counselors. PR 25-574 nominates Rhonda Brown to the Board of Professional Counseling as a professional counselor for a term to end July 1st, 2024. Ms. Brown has 20 years of experience focused on adolescent mental health and substance use issues. She holds a master's in arts and community counseling and has worked extensively within the juvenile justice system. Ms. Brown is a Ward 4 resident. PR 25-575 nominates Victoria Shirk to the Board of Professional Counseling for a reappointment as an individual with at least 5 years of experience in the field of addiction counseling for a term ending July 1st, 2026. Ms. Shirk has extensive experience in addiction counseling and trauma-informed care. She has served in various health organizations and holds a master's in counseling, specializing in marriage and family therapy. Ms. Shirk is also the only current member of this board. So she is also the chair as the only member of this board. And Ms. Shirk is a Ward 3 resident. PR 25-576 nominates Giovanna DeLoro to the Board of Professional Counseling as a professional counselor for a term to end July 1st, 2024. Ms. DeLoro specializes in trauma, depression, and anxiety. She's pursuing her PhD currently in counseling, education, and supervision, and is a licensed professional counselor in the district and Virginia. Ms. DeLoro is a Ward 1 resident. We held a hearing on these nominations on January 10th. At the confirmation hearing, among other things, we discussed the need to increase the applications for professional counseling licensure here in the district, and to streamline the licensure process, ensuring that counseling students are aware of the supervision hours that are currently required for licensure. The nominees also expressed support for the proposal in the Health Occupations Revision Act to move the Board of Marriage and Family Therapy under the Board of Professional Counseling. I'm happy to see that this board will finally grow from 1 to 3 members, all of whom are extremely qualified. I hope to see all 6 seats filled on this board very soon. And just for the public's awareness, as well as for my colleagues, you would note that 2 of these 3 nominees have a term that ends in July, a short time from now. And so we have already started conversations with the Mayor's Office of Talent and Appointments to submit the paperwork for these individuals so that we could just go ahead and get that process. And with that, Mr. Chairman, the committee unanimously approved these nominations on January 16th. And so I ask that the Committee of the Whole colleagues approve them as well, and that these nominees be placed on the consent agenda for the February 6th legislative meeting.
Thank you, Councilmember. Are there questions from members? Madam General Counsel, are these 3 measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Yes.
Madam Budget Director, do the measures, fiscal impact statements comply with council requirements?
Yes, they do.
Are there even fiscal impact statements attached to resolutions?
No, the rules exempt them. So that's how they comply.
But I have to ask the question anyway. It's right here. Thank you. Without objection, these 3 measures will be placed on the consent agenda for the February 6th legislative meeting. The last item from the Committee on Health is PR 25-578, Board of Occupational Therapy, Amalolu Mejekadumi. Confirmation resolution of 2024. Councilmember Henderson.
Thank you, Mr. Chairman. The Board of Occupational Therapy regulates occupational therapists, occupational therapist assistants, and recreational therapists in the District of Columbia. PR 25-578 nominates Olumulu Majekodumni. I'm trying to say it really fast, to the Board of Occupational Therapy as an occupational therapist for a term to end April 16th, 2024. He is currently the CEO of Triumph Therapeutics, which specializes in pediatric occupational therapy, and the vice president of the DC Occupational Therapy Association. Is a master's of science in occupational therapy from Howard University, and the nominee lives in Ward 5. We held a hearing on this nomination on January 10th. At the confirmation hearing, I discussed with Mr. Majekodumni the importance of raising awareness for occupational therapy among young people, communities of color, and especially in early childhood settings. He expressed support for the proposed legislation to enter the district into the Occupational Therapy National Compact, but expressed concerns over the proposal in the Health Occupation Revision Act, also known as the HORA, to merge the board with several other boards to create a new board of rehabilitative therapies. He explained that each occupation has unique requirements and trainings that should not be overlooked. The committee unanimously approved this nomination on January 16th. And as with the other nominees for the Board of Professional Counseling, this nomination has a term that expires in April. So once again, we have already asked the Mayor's Office of Talent and Appointments to go ahead and submit his paperwork so that we can have a timely processing of that. And with that, Mr. Chairman, I ask that this nomination be placed on the consent agenda for the February 6th legislative meeting.
Thank you, Councilmember Henderson. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes.
Thank you. Without objection, this measure will be placed on the consent agenda for the February 6th legislative meeting. The last measure for agendizing is Bill 25-345, Secure DC Omnibus Amendment Act of 2024, reported out of the Committee on Judiciary and Public Safety, chaired by Councilmember Brooke Pinto. Councilmember Pinto.
Thank you, Mr. Chairman. The district is experiencing a crisis of increased crime and particularly violent crime that is unacceptable and causing way too much harm in all of our communities. District residents deserve our urgent action to improve public safety. Secure DC includes over 100 targeted interventions that fill critical gaps in our current public safety ecosystem to first prevent crime and end cycles of violence. Second, increase accountability. And third, enhance government coordination and oversight. In 2023, DC experienced 274 homicides, the most homicides the district has experienced in 25 years. A 39% increase in violent crime and a 24% increase in property crime. Given these troubling trends, we have heard continuous calls from residents, from our government partners, and advocates to urgently address this crisis in an urgent, comprehensive, and sustainable manner. Throughout the last year, I heard from and met with literally thousands of residents and advocates, held over a dozen public hearings on each of the bills that are included in today's omnibus, held community meetings and forums and public safety walks in all 8 wards, coupled with all of these conversations. Many residents and advocates have offered passionate and well-reasoned arguments in favor of the district doing more to address root causes of crime. I strongly agree that addressing root causes of crime is critical to our need to reduce violence. This is particularly important in the context of housing, human services, and our education agencies, none of which, of course, the Committee on Judiciary and Public Safety has oversight over, but that I look forward to a continued partnership with my colleagues to address these needs and challenges. With that said, the robust public engagement process the Committee of the Judiciary and Public Safety convened throughout the last year makes me confident that Secure DC will make DC residents safer and more secure. A number of provisions focus on preventing crime, including by providing grants to non-government organizations to provide safety personnel and infrastructure, investing in reentry training for our returning citizens. Other provisions focus on ensuring greater enforcement and accountability. As we all have talked about many times, without swift and certain consequences, we will continue to see a lacking sense of accountability that we know has contributed to the current circumstances in the district. Secure DC includes many proposals that specifically aim to close the revolving door in the criminal justice system. These proposals focus on deterring the small number of individuals who are repeatedly engaging in violent crime and temporarily and securely holding the most dangerous individuals to prevent more harm in our communities. Mr.
Without
Chairman-
objection.
Thank you. I also want to note, along with the many residents and advocates who have engaged with the committee, I remain concerned about the impacts of incarceration on the most affected communities, and I'm concerned that Black and Brown residents are disproportionately represented in our incarcerated population. I'm also concerned about the disproportionate impacts of crime on Black and Brown residents and on neighborhoods that are low income and underserved. I believe that greater enforcement and accountability, along with greater prevention and coordination efforts, are necessary to make the district safer and more secure for all residents. Furthermore, the committee's recommendations regarding enhanced data sharing and greater government oversight will assist our agencies, policymakers, and the public in evaluating the success of our programs in preventing crime, connecting victims with resources, and measuring the performance of our first responders. Supporting accountability and transparency of our government agencies is essential to improving the safety and reliability of the provision of services to the public. And these values are no more important than for our police. I believe that accountability of our officers and transparency for the public regarding sustained violations of police conduct are critical to our efforts, while also maintaining employee privacy records for things like medical treatment. I also believe that we must support our officers to engage effectively and appropriately when potential harms to the community occur. Secure DC protects these values to maintain the safety, efficacy, accountability, and transparency of police community engagements. District residents cannot wait any longer to be and feel safe and secure in our communities. I want to thank all of my colleagues for your participation in this process, participating in hearings, introducing your own legislation, attending public safety walks, offering meaningful suggestions to this legislative language. I have worked with literally all of you on this effort, and this is an opportunity and our opportunity for the council to make an important step and to say that we are moving our city forward in a safer and more secure direction. I know that moving our city forward in this type of direction takes all of us. Everyone here on the council, the mayor, the attorney general, the United States attorney, the public defender service, the courts, all of our agencies, our residents, our faith leaders, school leaders, and really each one of ourselves asking how we can play a role in building safer communities each and every day. I am confident that the process we have undergone to get here today is the right one, and that the provisions of the Secure DC Omnibus are necessary steps taken as a whole to effectuate the improvements that we need to make DC residents safer and more secure. With that, I ask Mr. Chairman that this measure be placed on the agenda for the February 6th legislative meeting.
Thank you, Councilmember Pinto. Are there questions from members? Councilmember McDuffie, then Councilmember White.
Thank you, Chairman. Obviously have a question, but want to begin by acknowledging Councilmember Pinto and her team and all the work that you all put on this, put into this effort to put this measure before the council today. I believe that it is of the utmost priority to the council to work together across government. That includes the executive branch agencies, the mayor, as well as our federal partners and the agencies associated with them to find solutions that are going to make our residents safer. As I've said repeatedly, our policies really have to focus on three things: prevention, accountability, and opportunity. We got to prevent crime before it happens. We have to put resources in place to hold accountable those individuals who commit violence in our city. And we absolutely have to provide opportunity for our residents with the highest need. The committee print does that in several ways, including expanding the private security camera program, protecting child victims of sexual abuse, and establishing a new criminal justice coordinating council pre-arrest diversion task force. I do have some concerns, and I'm going to spend some time between now and first reading, working with Councilmember Pinto about the print. And I'd like to maybe just raise a couple of things so that you're aware. The expansion of DNA collection by MPD for individuals who have merely been arrested for certain crimes and not convicted. The reversal of the data collection transparency and police accountability measures, I believe were and are useful for transparency, which I know you care about, and the public's access to how we police in the District of Columbia. The permanent expansion of pretrial detention, I know it's something I supported over the summer, but I think it's important as we contemplate making that measure permanent, that we think about the best way to evaluate it to ensure that it is a policy that actually keeps our residents and visitors to the nation's capital safe. And so I want to make sure that we are spending some time addressing this between now and first reading. There's some other things that I have noted that are concerns for me. I don't think I want to list them all in this moment, but I think the takeaway is I know there's been a lot of work that you've put into this, and I appreciate all that work, and I look forward to working with you even more to address some of the concerns that I have that are still in this measure.
Councilmember Pinto.
Thank you, Mr. Chairman, and thank you so much, Councilmember McDuffie, for all of your work in this space and for sharing some of your outstanding concerns. So to address a few of those, DNA testing, this is done in 31 other states. This is not an out there proposal. As we heard this morning in our meeting with the Sentencing Commission, one of the reasons for our prosecutor not charging a case is made up for later when we do have access to DNA testing. And that was one of the gaps that we talked about this morning. And so I do think it's important for felony cases, which are our most serious cases, to allow for testing of DNA to determine if the perpetrator has been repeat offending. And this will be really important for the maintenance of that information in our CODIS system. In terms of the accountability, I reject the premise that this is a reversal. Police accountability is extremely important. Secure DC ensures that when there is misconduct with our police department, that not only there's an opportunity for discipline within the department, that our Office of Police Complaints has unfettered access to that investigation, that the public has access to a public database that's not currently in existence. So that's a value that is embedded throughout Secure DC every step of the way. That is what is and was very important to me and my team in this. And then in pretrial detention, of course, it is hard to prove, but for one intervention, something wouldn't have happened. But we know there are several cases of violent offenders, even for some of our most violent cases like homicides, that have been able to be held pre-trial that but for our action this summer would not have been. And so to your point about measuring efficacy of this intervention, I think it's really important that we be consistent, that we don't say in July, we're changing the rules, and then in January, we're going to change the rules again. We need to be able to see over the course of the year, all of these ways that these interventions are working and not working. And I believe that giving judges more discretion to hold somebody for committing a crime of violence, still a rebuttable presumption, if they're not a danger to the community or they're not a flight risk, is a really important part of what we need to empower our judges to do.
Councilmember Robert White.
Thank you, Chairman. As you said, Councilmember Pinto, crime is an incredible problem right now. It's the number one concern for almost every resident, for good and obvious reasons. And I want to thank you and your team for doing so much work on this bill, for working with members of the council and the community, for including provisions from my whole government response to crime act and many other members' provisions. There's a lot in this bill, and there are some provisions I have concerns about, but I want to, because we're in the count right now, just focus on a few specific questions. I'm always trying to make sure, as everybody's yelling at us, do something. We don't panic and just do things, but do the right things that meet this particular moment and make us safer. On the drug-free zones, it's already illegal to sell drugs. It's already illegal to do drugs in public. And so the issue isn't that there aren't laws on the books. The issue is that we don't get to prosecution. And so I want to understand how the drug-free zone proposal makes us safer.
Sure. Thanks so much, Councilmember White. So, yes, it is illegal to do drugs and sell drugs in the district. In practice, we know that arrests and prosecutions for these crimes are way down. Again, something we talked about in the data this morning, only 5%. That's for a lot of things. One of it is with the challenges we've had with DFS. And another one is the practical way that a lot of people are selling drugs now is not a cash transaction. It is over the phone. And that's really hard to prove or witness for the police. We also have a practical challenge in those cases where an arrest is made, that if an officer takes somebody down to the station, books them, they're released because none of these are qualify for being held pre-trial. They're not violent offenses. And most of those cases are eligible for either a split sentence or probation, meaning the entirety of the sentence is suspended and served on probation. So in practice, we're hearing a lot of people say to police, good luck, you want to arrest me? Nothing's going to happen. And not only does that spread throughout communities, but it also disheartens officers from saying, I'm not going to spend half a day dealing with this booking if that's the reality. So drug-free zones are one additional tool to give officers to say, look, there are a few hotspots of crime in our city where there is not only drug activity, but a lot of these hotspots, there's weapon sales, there have been homicides, other shootings, harassment, threat, and groups of people taking over an entire corner that's now become a location for criminal activity on a repeated basis. Almost done, Mr. Chairman. So this gives the police a tool to say, okay, in these areas that have criminal activity of drugs, we're going to declare a drug-free zone for a period of 120 hours or 5 days. We're going to put a notice up. We're going to share that with the public. They're going to share the locations with us as the council. And then for that period of 5 days, if people congregate there for the purposes of engaging in illegal activity, they've now violated the law. And I think that's a important tool to give the police to disrupt these certain specific few but egregious areas of these repeat offenses.
Mr. Chairman, if I could finish this question, I have two more for another round, but if I could finish this question. Is really
without
fun.
objection.
Thank you. I'll be brief. So the issue of whether or not police arrest is a matter of discretion. The question of whether or not prosecutors prosecute is also a matter of discretion. This law doesn't change that discretion. The underlying issue is real. I don't see how this fixes the underlying issue. And without a comprehensive strategy for drugs and drug issues, then it seems like this activity, even if it gets disrupted, moves one block over. And so I'm worried here that we don't have a comprehensive strategy for addressing drug issues, but I also believe that police and prosecutors can today arrest and prosecute, and that the changes in law don't affect whether or not they do that.
So there are dozens of provisions in Secure DC that address some of the challenges we're seeing with arrests and prosecutions. It makes it easier to close a case when we have video footage demonstrating who did something. It makes it easier to bring a case of theft one when we're lowering the threshold from 1,000 to 500. It makes it easier to be successful in a prosecution if we're changing the definition of carjacking to make clear what it is we as the legislature believe carjacking to be. So while, of course, there is always discretion in police officers making arrests and prosecutors charging, that's why they were such an important part of this process and looking at thousands of cases where the gaps were, why decisions were made, and thinking how as a city can we plug some of those gaps to ensure that that discretion is within a more reasonable range.
Councilmember Lewis George.
Thank you. Thank you. I want to thank Councilmember Pinto and her entire committee for the work you've done. When you said you did a robust process, I want to say it was a robust process. Thank you for reaching out to each of our neighborhoods, meeting in our neighborhoods. Thank you for reaching out to council members and meeting with them. I do think you guys did a really great job at a robust process, and I want to note that and say that. I think this legislation has so many good things in it. I sort of characterize it, put it in like 5 different categories so that it can make sense, in which there was so many pages, which is we have a category of criminal offenses, many of which I think we had in our original revision of the criminal code. And so those criminal offenses are there. A category of investigative tools. I have pretrial detention, youth justice, good government, and then police oversight and accountability. So I categorize them in those categories just so that we can keep them there. One of my biggest concerns are the abandonment of vital police oversight and accountability reforms. That's something that we've unanimously passed over the past few years. I think the testimony, Director Peter Tobin testified at the hearing, and he had the most damning, I thought, testimony because he was outright saying like he thought these were rollbacks as a director of police complaints. And he said last year was the largest year, the highest number of police complaints that the Office of Police Complaints had received in his testimony. And then he said many of the actions that the council has put forward have actually never been implemented, meaning they were never funded. And so he said, I don't know how we can roll back something that has never been implemented or justify rolling back something that we've never implemented. So that's an area that I want to look in, just because I thought Director Tobin's testimony was he was honest and it was quite damning. And I don't want us to roll back those reforms. So I'm curious how you all reconciled Director Tobin's testimony that we heard at the hearing with moving forward on those particular things. The other question I had is the council, I thought, worked really hard during the temporary, and we changed the vehicular pursuit legislation in our temporary. MPD met with each and every one of us. And I thought we were working in good faith, and we came up with a tweaking of that piece that I thought we landed really well. But I noticed here that we're tweaking it further, and I thought we were just going to pass in the permanent, what we passed in the temporary. But I see we've added we're adding back in, boxing in, caravanning, deploying a roadblock, deploying tire deflation services, and those are being declassified as serious or deadly use of force. So I was curious why we were tweaking even further, since I thought we reached a good resolve during that temporary originally when we worked with MPD to make those changes earlier. And then my other question is with the DNA, whether I guess it's collecting DNA at time of arrest versus collecting DNA at time of charging, and what the difference is you see with collecting DNA versus an arrest versus a case actually being charged or papered. And I guess we're gonna have a second round, so I'll ask the other questions because
Well,
Phil's
I'm not
giving me
looking
this
forward to
look.
lots of rounds here, but if we could like.
My last question. Okay, well then I'll just pose the last question there. And so the other one is the pretrial, the expansion of pretrial arrest. I know working with members about this, but I think since the emergency bill went into effect in July, expanding pretrial detention for adults, the population of Department of Corrections has swelled by 30%, about half of which has been, I guess, attributed to more pretrial detention. And I know only between 1% and 2% of those under pretrial supervision in DC are rearrested for violent crime. And so right now, there are now 400 more people in jail on any given day, but our city is not safer. What evidence do we have that expanding pretrial detention has helped more than it has sort of hurt families? And what are you all looking at as far as potential options to narrow that?
Councilmember
Thanks.
Pinto, do you remember each of these 5 questions?
I do. Thank you, Mr. Chairman. Thank you so much, Councilmember Lewis George. So I'll try to take each of those in turn. So again, I reject the premise that this is an abandonment of our values. We believe, I'll speak for myself, I believe that we need to have a police department that is accountable when misconduct happens, and that the public has a right to know about that. That is maintained throughout that. I thought that Director Tobin's testimony was quite persuasive. We have worked with him on a number of provisions to make sure that that is throughout it. So the language that he was commenting on was not the language that we landed on in Secure DC. One example is for OPC, the Office of Police Complaints, to have unfettered access. So it was listed in current status quo as unfettered access, requiring the information be, quote, specifically related to the Police Complaint Board's duty. We add in Secure DC that it needs to be for an active investigation at hand. That's an or. So that was not very clear. We add an or to say, or it's for. So that's actually a broadening of their language. So this idea that this is rolling back accountability is just unfounded. There are several examples I'd be happy to go through with you on these clarifications. Vehicular pursuit is a similar statutory issue. So it is against MPD policy to engage in any of those activities that you listed: ramming, blocking. Those are not things that we want permitted. Those are not things that should be permitted. It was creating a confusion within the department to have it listed as a use of force, because some uses of forces in statute are permitted. And so we removed it to make crystal clear that it is completely prohibited, and it's not under the definition of use of force. So those will not be permitted. DNA testing, I spoke about this. There are some practical challenges with waiting until charging. One of them is after charging, the person would have to voluntarily come down to get tested. Another one is it would reduce our case closure rate, because like there was an instance, for example, where somebody was charged of a sexual assault. Several years later, they were charged again. And the third offense, we would have been able to catch them at the second offense because of the DNA testing at arrest. But because we're unable to do this now, it harms us. And again, 31 other states collect DNA at arrest. And then lastly, for pretrial services, we look at a lot of data. I think our pretrial services agency is doing a lot of really important work to make sure that people are connected to the resources and supports that they need. So you could look at percentage, you could also look at whole numbers of people who are reoffending the most violent offenses when they're on pretrial release. And that's the category of cases that we were most concerned about in making sure that we are, again, giving judges the discretion to hold somebody, and why I think it's so important to be consistent with that intervention over in permanent law so we can continue to track it. Thank you.
Councilmember Henderson.
Thank you, Mr. Chairman, and thank you to Councilmember Pinto. I'm gonna try to keep my questions brief because I'm a member of the committee, so I had an opportunity to engage on this. But I have two questions. So first, similar to Councilmember Robert White, I do have some concerns still around drug-free zones, and my concern stems from the knowledge and community that I know MPD is probably going to be petitioned to put up a drug-free zone in areas where individuals may be, there's either a substance abuse facility, or we have other types of treatment outreach options for individuals who are suffering from substance abuse disorder. So for instance, mobile syringe services, where we have grantees that may provide equipment, supplies, and things like that in a park that now might be disrupted due to a drug-free zone. And so, there are over 50 substance abuse disorder treatment providers in the district. Many of them, they do medically assisted treatment, which requires someone to come every day. It might also require that you wait outside of the facility in order to be seen for your appointment. What assurances do you have from MPD that we're not unnecessarily criminalizing someone who is literally trying to receive treatment and medication in the name of disrupting drug-free area? I have another question after this, but I'm breaking it up. Go ahead.
Okay. So thank you so much for raising this concern several weeks or months ago, because I think it's a really important one, and working with our team on this. So we have included a number of protection provisions in Secure DC to say, first, there has to be public notice when a location is established, and that we have to be made aware of it as well. And clarification that this law cannot be applied with the primary purpose of depriving people of social or medical services, for the exact instance that you talk about. If somebody is waiting in line to get drug treatment, they are not in violation of the drug-free zone. It's the activity that sometimes happens after, where people are victimized while waiting in line and targeted for these types of drug sales. I've also spoken with Chief Smith about this on several occasions, both at the public hearing and in other meetings and conversations, to make sure that the police department is crystal clear of what our intention is with this language, and what we want to make sure is not overly broad that could lead to other harassment or other issues. And so I feel confident that the language we have now addresses the concern that you raised.
Okay. I would also just note too, I appreciate you including the language that we added, that the directors of the human services clusters have to be also notified of a drug-free zone, which I hope will help mitigate some of these challenges and issues. My second question is a little bit different. So this bill, sorry, okay. Thank you. This bill would push back the enforcement date for the cashless retail ban to January 2025. And when I think about this particular legislation, when it was first introduced back in 2018, it was before the prevalence of electronic payment systems like Cash App and Venmo and PayPal and Apple Pay. And we're hearing from a lot of restaurants and bars, particularly concerned that requiring their employees and their staffs to have cash on the premises is now making them a target for robbery, especially for those who are doing the close up, right? Somebody has to take the money somewhere. In addition, also requiring them to purchase new equipment. So if we think about, say, Capital One Arena, for instance, which currently is a cashless facility, you don't even need there is not even a physical ticket to go into Capital One. You only use your phone. I'm curious, why did you choose January 2025, given that as we work through this process, that's not that long of a time of a delay, but also would you consider delaying it even further, given the new realities presented?
Sure. Thank you so much. So one of the things that was really important to me and my team in this process is that these are all bills that were introduced, had a hearing, had a very public process that are combined now in this omnibus. And there are very few exceptions or deviations of that because we wanted to make sure that, especially given the size of this bill, that this is not filled with surprises or things that we haven't had an opportunity to contemplate as a body or as a public. But one of the things that we heard on a repeated basis from folks throughout the hearing process was we need to readdress the cashless issue, both from employees who felt afraid leaving at night, carrying cash or working in an establishment with cash, and operators who were saying, frankly, they're not going to follow the law because the risks are just too great. And I think we as a government have to be consistent. When we talk about accountability in the law, that has to be for everyone. That has to be for residents, that has to be for businesses, that has to be for our own agencies. And so I felt very uncomfortable with a climate where people are getting held up at gunpoint, robbed, smash and grabs, broken into, oftentimes for cash. We had an example of a local business just 2 weeks ago where an individual came in, pointed a gun at the shopkeeper's head and said, "Give me all your cash." And she said, "We don't carry cash." And he left. And so I hear stories like this all the time. And so I thought it was really important to include in Secure DC. In terms of why we extended it a year, again, because it wasn't part of introduced legislation for a hearing to repeal this law, I believe that that was a fairer compromise to delay implementation for another year while we're in this state of emergency, and then revisit if that is a law that we should even be having as a district. But again, in working to address the trends that we're seeing now, I think it's important to be delayed for at least a year.
Perhaps then the date could be a year after the effective date of this act. Otherwise, you will have lost some months
Chairman.
as we work through the process. Thank you, Mr. Chairman.
Member Tran White.
Thank you, Chairman. I want to thank you, Councilmember Pinto, and your staff and all those, even executive and the council gave input trying to figure this thing out. The crime has continuously rised in the district as we have continued to try to create safeguards and different mechanisms to keep people safe. There are a couple of measures in this bill I'm still trying to grapple with. And I think that we all want to do something to address violent crime in the district, and many constituents feel like there needs to be some accountability, but also a balance to our laws. My general concern is around the bill that gives police powers that may be costly and may have unintended consequences. I do know there are a number of law enforcement, police unions, federal prosecutors who gave a lot of weight to most of these bills. But there were a group also of returning citizens that ironically agreed with a lot of the policies, but also wanted to add balance, and especially those who have paid their debt to society and came home. It saddens me that those provisions were not included in this bill that gave people an opportunity to get their lives back on track and avoid discrimination in housing opportunities, job opportunities, career opportunities, business opportunities. And so we were hoping to get some of those answers, Councilman Pinto, but to no avail. I'm concerned also with the reverse reforms, such as Act Now, where we're considering changing the council's legislation, longstanding petitions on police chases and use of force. With regards to the choking, I appreciate the positive change in the Act Now language to clarify that controlling a person's movement in brief, unintentional, and incidental contact with the neck are not prohibited unless they restrict a person's airway, blood flow, or breathing. Still, I have concerns. What does brief mean? How do you touch a person's neck or restrict their airways briefly in a safe manner? I don't know what that means. And in regards to the drug-free zones, I'm just kind of concerned to make sure it's constitutional. I'm not sure what's going to happen in the long term and the ability to enforce these drug-free zones. As Councilman Rob White alluded to, selling drugs in these areas are already illegal. We have a number of drug-free zones, And I heard the mayor talk about moving people along in these zones. And I'm not sure how that's going to play out in real time, especially with the lack of police force that has enough numbers to do that. Similarly, we had issues with complexity of policing and community policing and what that looks like on just communication levels all across the district. It is my hope to support this measure, Councilman Pinto, but some of these things still are having more questions than answers, even when I hear the testimonies and the response to it in the hearings. So I want to speak with you in the committee a little bit further to get some clarity as I continue to move forward. And if you can speak to the drug-free zones and what would change in that? I heard some questions, but I haven't heard that answer. What would this legislation do with these drug-free zones?
Sure. Thanks so much, Councilmember White. And if I may, I'll try to briefly address kind of a number of important points that you raised in order. So in terms of police powers and taking into account a lot of the really powerful and good perspective that we heard from returning citizens, one of the things that we heard most consistently was people want additional access to training and opportunities after they have served their sentence. And that's why we've included a hospitality training program in the DC jail to set people up for success upon reentry and ensure that that program is connecting with employers while you're serving your sentence. So there's not this gap. I know that the council in last council period addressed a number of concerns around record sealing, and we're happy to continue working with you on some of those issues. We're also working with our employers on looking at other insurance premium mechanisms to incentivize hiring of returning citizens. I know that this council has also done away with housing providers looking at criminal histories, for instance. So there's a lot that we're trying to do on various different spaces to address that need. In terms, one other thing I wanted to mention that I heard from returning citizens that really swayed me and was very moving was the provision idea around consent searches for parolees or for people on pretrial release to consent to be searched for weapons when you're in a public space. And I heard from a lot of people who shared how traumatizing that would be and how after you serve your sentence, you may feel like you're constantly looking over your shoulder. And so I took that out entirely because I was really moved by that testimony. In terms of your comment about incidental touching, yes, we changed the language. So it's absolutely banned to have a chokehold. It is banned to have an asphyxiation restraint or blocking of an airway. We have an exception for, not an exception, we have a definition of what constitutes a chokehold to make clear that if there is brief incidental touching of the back of the neck, for instance, that's not automatically going to lead to discipline. So in practice, how this works, this is a real case. A woman was in distress. She was thrashing her head against the back of a wall. She could have knocked herself out. The police officer, what I would describe in care and compassion, put his hand on the back of her neck to prevent her from knocking herself out. That officer is now under discipline because it is interpreted that that's restricting movement. So we really tried to make the line very clear. Chokeholds, absolutely not okay. But if there's incidental brief touching of the neck in the context of an arrest, you're not immediately going to be placed on discipline. In terms of drug-free zones, I am confident that this is constitutional. This has passed gotten legal sufficiency review by our Attorney General, who would be responsible for defending any law that was challenged. And I share the legal analysis that it is dissimilar enough from an anti-loitering law that has been considered by courts in the past. And so I'm not worried from a legal perspective there. I do think it is important to give the police this tool to disrupt these hotspots again, coupled with continued arrests and prosecutions of drug crimes, but to send a clear message that people cannot engage in criminal activity in the same location day in and day out without any intervention. That's not a sustainable way to go. And I will note in my Ward 8 public safety walk on this bill, Councilmember White, that this was the number one issue that residents raised to me as their number one request, was for more interventions for some of these hotspots. And then lastly, I wanted to note your comment about policing and some of the provisions in Secure DC about policing. We worked very hard to get this balance right of maintaining the value of ensuring police not only accountability, but transparency for the public when there's misconduct. So this is why in our public database, for example, anybody in the public will be able to see if there's police misconduct that involved a public interaction, that involves a criminal issue with an officer, that involves a issue with the court of an officer. And we tried to make the distinguishing line that the public doesn't need to have access to the information if it's unrelated to those categories. So if a police officer sought mental health treatment, for example, that's something that we want to encourage. We don't want to stigmatize that. There is no reasonable reason for the public to have access for that information. And so that's the dividing line that we tried to make in all these provisions, supporting police accountability and transparency and supporting employment rights for our officers in a way that we would expect and demand for every other public agency.
Councilmember Fruman.
Thank you very much. And I want to join in thanking you, Councilmember Pinto, for all of the work that you've done. This is enormous. And I do think that you pulled this together in a way that gets us close, and you're hearing all the different kinds of questions. It moved a little between the day of your press conference and the day of introduction, and now a little here. And I think we can all expect more movement in maybe multiple directions. Could be that the date for cashless, the moratorium on cashless transactions gets put off, and so we'll see where it goes. I had a couple of questions about a few words, and it may be that you answered the first one partly with the scenario that you described in the neck restraint setting. In the neck restraint setting, I did the MPD Community Engagement Academy over the summer and heard from a lot of officers, and went to roll call the other day and heard from a lot of officers. There is a lot of angst about being called on the carpet for things that were not intended to be something negative, and best intentions. And that has a big effect from my experience inside of the department. You took out the movement, that you can't touch the neck and in order to control movement. And I take it that part of what you're thinking was the scenario, not a hypothetical, but the scenario that where the person was thrashing around and the officer put his or her hand on the neck in order to control the movement. But there's another scenario of an officer, putting their arm around somebody in order to control the movement. And the officers in the George Floyd setting might say that's what they were doing. And they might say, we didn't have the intent to cut off the breathing. We could miss that scenario, it seems to me. I want to get this right so that the incidental things are not captured, but I don't want to miss the kind of scenario that I'm talking about. Did you think about that? Did you think about alternatives of how we could get it so that scenario where somebody puts their arm around somebody's neck in order to control the movement, not to cut off the breathing, but they happen to cut off the breathing? How do we deal with that?
Thank you so much, Councilmember Fruman. And it's a really important point and why this drafting process was so comprehensive and thinking through what we're trying to prohibit and coming up with as many examples as we could. So where we landed is it's completely banned to have any restriction of breathing, airway, or blood flow. That's all prohibited. So it's not about the intention. It's about what actually happened. So your example of having an officer's arm around someone's neck is completely prohibited. In terms of a slipping or the incidental issue, that's why we created the language as an or. So it says that the exceptions are the contact with these areas of the neck is brief, unintentional, and sorry, it's the and not or, and incidental. So the examples of anything that's intentional, anything that's not brief, all would continue to be prohibited.
Okay, so that's super helpful. And I guess the purpose, intent, or effect. So it wasn't the purpose, it wasn't the intent, but it was the effect of the way in which they held the person. That so that's very helpful. Thank you for that. Another one I think it's the definition of
Council member, be mindful of time.
okay, I'll be quick. The use of force, and it used to be resulting in the loss of consciousness, and then now you've changed it to resulting in the loss of consciousness, protracted loss of consciousness. So what is that? What is protracted, and why is it not a use of force if somebody loses consciousness for 2 seconds, but whatever it is that you define as protracted? Help me understand the addition of that word.
Sure. That was a conforming language because that's how it's defined in numerous other places throughout the code. So that was just to make sure it's consistent for interpretation.
All right, thank you very much.
Thank you.
Councilmember Parker.
Thank you, Councilmember Pinto, for your work on this legislation. As everyone has already said, there has been a lot of work, and what's happening on the streets of DC is unacceptable and is an urgent matter. And so I'm hoping that we can move on something soon. To the neck restraint conversation, it's worth noting the mayor's proposed limit on neck restraints were for officers that had a purpose or intent to asphyxiate, whereas the committee print maintains the ban for neck restraints that have the effect of asphyxiating. And I think you landed in the right place. It's not important of the purpose or the intent if someone is in fact dead as a result. A few questions. Section 5, as it relates to, I believe, FOIA and requesting information about officer misconduct. The language of the bill reads, for the purposes of this subsection, disciplinary records means any record created in the furtherance of a sustained disciplinary proceeding. Do you have data on how many requests are made annually and how many are sustained versus not sustained? And if you don't have it, if you could follow up with that. I know there has been a lot of concern. I share the concern around limiting transparency for officer misconduct or even the allegations of officer misconduct. I also think it would be important to have numbers. Are we talking about 10 instances, 100, 500, et cetera?
Sure. Thank you so much. I'd be happy to follow up with that information, but just so everybody's clear, the current law is being interpreted both by the Office of Police Complaints and by MPD as only qualifying for sustained allegations. So this is not a change to that law.
Oh, the change is regardless of whether the matter was fully adjudicated or resulted in policy training, et cetera, et cetera, et cetera. And so I'm reading that as we are limiting the information that we are willing to make available publicly via FOIA.
Well, we're not limiting anything because this is all unfunded, so it's not in effect. So this will lead to much more transparency and accountability.
If we could follow up and we could do that offline about the data, I think that would be important. On the drug free zones, I will say there are many Ward 5 neighbors that are looking for some type of relief and are hoping that this drug-free zone policy will provide MPD a tool to disrupt what's happening in neighborhoods like Trinidad, Carver, Langston, and others. I would echo concerns around sustained effect and making sure we coordinate across agencies like DBH to make sure we're connecting people with services. And then lastly, it is worth noting this legislation.
Are these questions or
I have
statements?
This is my last question.
Please?
This legislation expands mandatory minimums. It's worth noting this is a year after we voted on legislation to eliminate all but one mandatory minimum. Just for the record, how many additional mandatory minimums are added via this bill?
Okay, thank you. I'm gonna try to go in order. So we talked a little bit already about the sustained versus unsustained issue, but also just to clarify, this brings it in line with what's provided in the database. So our theory is that things should be there's a question of what's provided in the database, and then there's a question of what's FOIable for people seeking additional information. And again, our hope is not to change the scope around what's listed and sustained, but to make clear that information that has nothing to do with those three categories of anything with a public interaction, if an officer was rude to a member of the public or used force, all of that's included. Anything that has to do with an unrelated criminal investigation or an issue with the court, all of that's included. But if the officer, was late or fell asleep on the job, things like that happen in a multi-thousand person agency and that are subject to discipline appropriately, are not appropriately subject to public disclosure for all of us to know that officer's name and badge number for what they did. So that was our theory there. In terms of drug-free, we talked a little bit about that, but I totally appreciate your points about DBH. I will just say there have been several locations, and I've worked with colleagues, Councilmember Nadeau, on one that we share a border on, for instance, where we have tried to send DBH over, tried other drug interventions, tried offering services, funded new positions for, and yet are still hotspots of criminal activity on a daily basis. And so I totally agree that DBH needs to be a part of this. But sometimes there are locations where people are not interested in services, and the behavior needs to be disrupted. And then the mandatory minimum question. So Secure DC establishes a number of new firearm offenses. Things like endangerment with a firearm. This is what we're seeing when people are shooting a large number of bullets into the public, for instance. That's not its own crime right now. That should be a felony. That is increasing the maximum penalty from 1 to 5 years. Discarding of a firearm. We're having this problem a lot where people are fleeing the scene, throwing their weapon into someone else's backyard or a tree box. Children have found these guns. Tampering with serial numbers, receipt of stolen firearms. And then there are a number of penalty enhancements for certain vulnerable victims that increase the maximum allowable, which is different than the minimum maximum allowable penalty by 1.5. This is for children, victims, seniors, Metro Transit workers.
I know I'm over time. My read is that there are 2 additional mandatory minimums, either here or offline. If you can confirm that is correct. I'm aware of the enhancements as well as the data for the request for sustained versus unsustained police misconduct.
What are
Thank
the
you.
2 additional mandatory minimums that you believe are here?
Say it again.
What are the 2?
There is, I would have to look it up. I have it in writing, but if you give me 30 seconds, I can tell you.
Please, because my impression is that there's some amendments to the criminal code. Keep looking while I'm talking, that there are amendments to the criminal code in this bill that where there already is a mandatory minimum rather than creating one. So we ought to have this clarified.
As Councilmember Pinto mentioned, it expands the reach of 7 existing statutes. And then I believe section 16 and section 20. I again can find that.
Could you read those sections?
If you give me a second.
Okay.
So I'm trying to do this in real time.
Okay, we're trying to look up to the sections. I just want to make sure we make the distinction between a minimum and a maximum. And as we talked about the Sentencing Commission this morning, there are ranges of allowable penalties for different offenses. And so a number of these provisions extend the allowable maximum which again offers more discretion, versus a hard mandatory minimum kind of requiring that number of years. But if we're, I'm happy to follow up with you offline to make
Yes.
sure we're all in
I will get
alignment
that
on
answer
that.
for you.
Thank you.
All right, so, but Councilmember Pinto, you believe they're not creating new mandatory minimums?
We will take a look to confirm.
My team's estimate is there's two, and I'll get that confirmation.
Well, maybe we can get some clarification before we're done. Councilmember Nadeau?
I did think of mandatory minimum as a requirement that
That's
has
what
to
a
be met.
mandatory minimum is.
Versus there are sections where we are allowing judges more discretion to give a sentence range, but that's different than a strict mandatory minimum. So yes, I don't believe there are hard, strict mandatory minimums in this.
All right, let's be clear, and I'm picking up on what you just said, Councilmember Pinto. A mandatory minimum in the law is where the law prescribes a range, let's say 5 to 10 years. But then there's additional language that says that the court shall prescribe a minimum of X number of years. And the language is very clear and it's precise, and there is no discretion to the court with a mandatory minimum. So
Okay, then that is correct. We do not have mandatory minimums in Secure DC. New mandatory.
Councilmember Nadeau.
Thank you, Mr. Chairman. Two things. One, there was much said about the anti-loitering zones, and I'm not going to really try to expound on that. But I did want to clarify something that Councilmember Pinto said, which was that we've made investments in these areas in hotspots, and it hasn't moved the needle. I just want to be clear that we did fund investments in this fiscal year, but those grants have just been signed last week. So we don't have the results from those investments at this time. But the reason I wanted to be recognized was I wanted to ask about cashless retailers. So, we had a very specific intent when we passed that law originally. And, it's been mentioned a few times that the technology has changed. Putting this off a year, I know would be helpful to some of the businesses that are concerned about it, but I would rather not put it off for a year if we're not going to study the way things have changed or get some more information to actually review. So I wanted to ask, could our budget office, I said it slowly so Jen could hear, could our budget office review the landscape of cashless consumers to see how it's changed since we first passed the law and to determine how we can ensure that we are supporting folks who don't use cash while also not putting businesses at risk? In the event that we delay this, we would at least then have something to review before we made a final decision about whether we wanted to continue implementing it. We can say, oh, a lot of people use Cash App or Venmo or whatever it is now, but I don't think any of us really know or have the data. So if that's something that we could study, I think would help us maybe move forward as a body on this particular topic.
There's a provision in the rules allowing members to ask the budget office, but I don't know if the budget office is prepared to answer today, but let's see.
Thank you for the request. I will go back and speak with my team, and then we will reach out to you later this week.
I was just so
Thank
impressed
you.
by the report on the ATEs that I felt like we should keep the momentum going. So
Thank you very much.
yes, thank you, Mr. Chairman.
Thank you. Councilmember Robert White. I think the question was to the budget director. Councilmember Robert White.
Thank you, Chairman. Another provision I wanted to ask about, Councilmember Pinto, was the provision limiting the Office of Police Complaints access to information when they are investigating allegations of officer misconduct. Why would we want to limit what the Office of Police Complaints can access?
Thank you for the question, Councilmember White. So as another colleague asked about, this is not limiting, this is expanding. The Office of Police Complaints currently has unfettered access to this was required in the Comprehensive Justice and Policing Act, required that the information be, quote, specifically related to the Police Complaint Board's duties. So we have added an or to that to say, or a current investigation. That's aligned with how the Office of Police Complaints and MPD are interpreting it now, but we've had a lot of delays in them requesting this information and saying, well, that's too broad, or delays in getting back to us. So our hope is that by clarifying this language, it makes it much more likely that everybody's on the same page of what the Office of Police Complaints has access to, and that they get unfettered access to that information.
Okay, so your read is that this expands and does not contract access to information by Office of Police Complaints.
Yes.
Okay.
And I just want to read this one more language because I had a different red line. The executive director acting on behalf of the board shall have unfettered access to all information and supporting documentation that is directly related to OPC's investigation into an officer's alleged misconduct or specifically related to the board's duties under the paragraph. Right now, it's just the or specifically related to the duties of the board.
I appreciate that. The last provision I had a question on, this has come up in conversation already. It's about removing officers' names and badge numbers. I understand your thoughts on that. I do want to flag or ask a question about the current law, I believe, requires that MPD include the name and badge number of officers who are coming forward with disciplinary action that includes firing. I've gone through reports for many months, and I don't see any of that information available now, and I believe it's supposed to be. Is your understanding that that information is supposed to be available now from MPD?
So, no, because it's not funded. So this clarifies that information should be available to the public about the hearings that are going to happen, but we don't need to have access to the officer's name and badge number. But under present day, none of it's happening because
Okay.
none of it's funded.
I thought it was funded, but we can clarify that with the budget office later. So I appreciate it. I know there's a lot in this bill, so you got a lot of questions. Thank you, Councilmember Pinto. Thank you,
Thank
Chairman.
you so much.
I believe there are any more questions? Don't do it. Don't do it. If you don't, if you ask a question, Councilmember Parker will probably have another question.
Anita hasn't gone yet.
I haven't had a chance, Mr. Chairman. I have a question, and I, of course, want to commend my colleague for her work. So thank you. Thank you very much, Chairman. This is a discussion, and I recognize that, and I think we all are very privileged to have this opportunity. I want to start by expressing appreciation.
Oh, this is for questions. This is not discussion.
But there are questions within what I say.
Okay.
Thank you so very much. Again, appreciation to Councilmember Pinto and her staff for the work that went into developing and finalizing this legislation, which is a combination of input from council colleagues, Mayor Bowser, and others. We all are very appreciative of the work because it's our duty to analyze this legislation very closely, given its size and wide-ranging scope. There are high community hopes that the final bill will make a resounding difference towards restoring public safety throughout the city. And I think this bill addresses crime in many different ways, including addressing retail crime, enhanced penalties for violence and weapon charges, adding a police misconduct database, removing provisions of unconsented weapons search of our returning citizens in public spaces, Regrettably, it does not inform how to quickly increase the number of officers that are considered by many as the way to address crime. Many approaches are needed to address the street violence experienced daily, and this bill represents a combination of some of the ideas and strategies towards restoring peace in our city. However, there are several provisions that I believe deserve more discussion, including police accountability and transparency, and maintaining public oversight of police services is critical to improving public safety and enhancing the accountability issues that we speak of. We want law enforcement to do their jobs. For example, I agree with changing immediate threat to imminent threat in order to allow more police pursuits. But I want transparency to be maintained. And for this reason, I believe that MPD should be the entity that determines, should not be the entity that determines what the public knows about officers' conduct. And I look forward to additional work on this bill prior to final passage, including consideration that the Police Complaints Board maintain police misconduct database. I think that in 2020, when I joined, Councilmember Vincent Gray. 1 minute, sir.
Is there a question in there?
Yes, it's coming. It's right here.
Please.
Okay. When I joined Councilmember Vincent Gray to create the Police Reform Commission, the availability of information that was kept in this part of recommendation was so important. The proposed change that says that a defendant should get a jury trial once in cases where the law enforcement officer is the alleged victim, if they were in uniform or acting in an official capacity at the time of the offense. Well, this limitation was very concerning, as presented in the original bill, thanks for the changes that have been made in the committee print. And finally, I want to speak about Section 9, which creates the apprenticeship for our incarcerated residents in partnership with existing hospitality and culinary arts career training and education programs operated in the district. While this is a very good idea, it should be expanded beyond culinary hospitality training. And so my question to my colleague is, how can we work together with my committee to see how we can expand the fields of training for our incarcerated residents to other areas? I certainly don't think we want to be in a situation where one particular category of industry is perhaps becomes inundated with one type of individual. We want to give everyone who has an interest in culinary arts the opportunity to become engaged in that very important industry. In fact, I believe by providing some incentives or financial relief to DC businesses that hire former offenders, perhaps by using our DOES Project Empowerment Program, we may be looking at one such solution. And so my question again is, how can we expand to other occupations and industries in the city for our returning citizens and for those that are in the DC jail?
Sure. Well, thank you so much, Councilmember Bonds, and for your partnership on this bill. So I will try to go in order. So in terms of police officers, in this year's budget, we funded more positions for the police, including tuition assistance, hiring bonuses, housing assistance. Just last month, MPD had the highest incoming recruitment class that we've seen since 2019. So things are starting to head in the right direction. It's of course going to take us a while to build up the force, but we will continue those efforts. We also need to do everything we can to make sure we're not losing officers due to attrition, which is what a lot of these provisions in Secure DC will help with. In terms of transparency, I've kind of talked about today, but I do think that this bill does a lot for police accountability and transparency when there is misconduct. I also think it's important that we get the balance right, that the public not have access to discipline issues in the police that have really nothing to do with a police officer or an interaction with the public. Things like seeking mental health treatment, things like being late to work, or falling asleep on the job, even things that we don't want to see, but that I don't think the public has the same level of interest in as they should about a police interaction with the public. And so that's part of the dividing line. In terms of the jury trial, we made clear, aligned with what the Police Reform Commission recommended, that if there is an officer involved interaction, then there can be a jury trial demandable. But if it's an officer who is off duty and is being charged with something wholly unrelated to those functions, then that's that need is not there. And then lastly, on the training, I'm so excited that there's enthusiasm for this provision and want to see it expanded even more. I'd say we've got to start somewhere. And one of the things that I hear often from returning citizens is, you know, I want more optionality of things to get trained in or to do. There's a lot of options sometimes in construction, for example, which is great for some people, but the hospitality industry, we've included not just culinary, but hotels, conventions, food service, cleaning. There's so many different options. And that's why we thought the hospitality industry was a great place to start in expanding these cohorts for training. Absolutely. If folks want to work with me on hospitality training for other segments of the population in DC, would love it. If we want to work on other training opportunities within the DC jail, would love it. But again, we have to start somewhere in a feasible way. And my view is we've got to get these things off the ground so we don't think too big at the expense of actual movement. So that was kind of our theory here that we're really excited about. Thank you.
Thank you. And
Councilmember Bonds.
finally, I just
You,
if I
let's
could
see,
have
you're 7 minutes. With a 2-minute, you're 7 minutes. If there's no objection, please.
Thank you very much, Mr. Chairman. Finally, I understand the fiscal impact for this bill is around $5 million in FY '24. Is that correct?
Sorry, one moment.
Madam Budget Director, what's the fiscal impact?
It is 4.5 million in FY '24 and 42 million over the 4-year plan.
Thank you very much. I think it's just a small amount towards on the road to public safety in our community. Thank you very much. Thank you, Chairman.
Thank you, Councilmember Bonds. Thank you, Councilmember Pinto. Councilmember.
Very quickly, I wanted
We've
to.
been over an hour in questions. Just want to point
I
that
wanted to
out.
come back to the point that we were discussing earlier.
Quickly.
And it's less a question and an acknowledgement of Councilmember Pinto's point, but under section 31, the unlawful possession of a firearm where the serial number has been removed in lines 21, 26. There is exception for the suspect to be charged with a fine or incarcerated no less than 2 years, nor more than 5 years, or both. I guess the addition of the fine allows for the judge to have
That's not a mandatory
an
minimum.
option outside of a mandatory
Not
minimum.
because there's a fine, but that language is not the language for a mandatory minimum.
I am understanding that now, but as it reads here, if we take this at face value, if a judge were to sentence someone to jail, the language here suggests that it would have to be no less than 2 years, which in effect is a mandatory minimum, although it doesn't say those words.
Although I think, for example, the judge could suspend, he could sentence 2 years and suspend.
And the judge could suspend the charge. And so that was my understanding and or interpretation originally when I flagged the 2 areas. So thank you.
Councilmember Lewis George.
I just had a question. A number of people have reached out and asked, are we gonna have a RIA for before or on February sixth? Do we have a status?
Madam Secretary, do you want to speak to that?
Sure, good afternoon. As you know, most recent court director has resigned and I am severely short-staffed at the moment. We are working to publish a RIA by Friday, if not by the weekend for the latest. I want to give the council and members of the public at least a week or so to digest the RIA. So our goal is the end of the week.
Thank you, Madam Secretary.
And actually, I should have brought this up at the administrative meeting today and I didn't, but then again, we kind of used up all the time. There is right now an understaffing in the council's office on racial equity. And so the Corps is going to be struggling with getting RIAs out, or RIAs that are as comprehensive as we're used to seeing, or RIAs that are timely. For this bill, there was a placeholder RIA that was issued, a practice that was done last year as well. So it may be before our next legislative meeting when we have the breakfast that we could talk about just so that there's an awareness on the part of all members and some flexibility given with regard to the RIAs. Thank you. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be on the consent agenda for. All right, the bill will be on the non-consent agenda for the February 6th legislative meeting. Let me just say that the public who's watching this has seen a lot of questions asked for committee of the whole. When a measure comes before us, there is not an opportunity for discussion or amendments. But I am confident that this council will move forward with legislation and through our ordinary robust process. So I expect that there will probably be some amendments, but that this legislation will be approved by the council. You have to vote twice. The first vote will be on February 6th. Depending upon my sense of things, there either will be second reading on the 20th or March 6th. And we will proceed with this. So I just want the public to understand that. That concludes the measures that we have on the agenda for this committee of the whole meeting. We have a legislative meeting on February 6th, probably a committee of the whole at the beginning. The time is now 3:15 p.m. and this meeting is adjourned.